The witnesses for the state are Christopher McGregor, Edwin Kent, Officer Phillips, Officer Todd Nealon, Mary Grace Mcnatt, and Marivik Milton. The critical evidence used against Mcnatt is one letter describing instructions for hitmen, an index card with personal information about the two women, Marivik Milton and Mary Grace Mcnatt, an audio tape of 2 meetings with undercover officers, and 1 page of notes, once again containing personal information about the 2 women. The police reports were not introduced into evidence, despite how heavily the court relied on testimony pertaining to these police reports, which is a violation of law, civil rights, and due process. The prosecution starts with the direct examination of McGregor. It does not start off well. Knecht asks McGregor if one of the officers with the Pasadena Police Department brought a possible solicitation case to his attention, and he says yes, Volume 3, page 21-1. However, later during cross-examination, he changes his story to being assigned the case on November 8th, which is a drastically different timeline, much further from the November 30th arrest of Mcnatt. On Volume 3, page 34, he is further cross-examined and asked if he had any text messages back and forth with the prosecutor, Knecht. He answers that it's possible, and on page 35, he states he doesn't have those messages anymore and did not preserve them, further undermining the credibility of the case. It is to be noted that in McGregor's police report, it contains much information not included in the trial. On page 35, it states that he instructed Kent on November 8th after speaking to Knecht, and Knecht giving him instructions to obtain an incriminating audio recording to further the investigation. This contradicts the claim by Knecht in her opening statement, Volume 3, page 16, Hanschvers, that the letter is what triggered the investigation, which is not true. In McGregor's report, he tasked Edwin Kent to gather incriminating audio with his cell phone. On November 11th, Kent reported back via telephone stating that he had failed to gather the recording for reasons that cannot be deciphered from the redacted police report. However, he then stated to McGregor that he obtained instructions for the hitman as if to substitute the requested audio with the letter. McGregor then contacted Knecht, reporting the failure to obtain audio but mentioning that he had obtained the letter. McGregor recommended involving the narcotics team to obtain the audio, and Knecht agreed. This demonstrates that this entire case was orchestrated to frame, coerce, and entrap Mcnatt under any circumstances, after repeated failures to establish probable cause. Even if the letter or index card were authentic, the officers did not take them seriously as probable cause initially, and only settled for them after their case lacked sufficient evidence. This constitutes official oppression, conspiracy, and malicious prosecution, as well as violations of the Code of Criminal Procedure, constitutional rights, and civil rights. Now, Edwin Kent comes forth to testify. Under direct examination, Volume 3, pages 42 to 43, he states that in October or November, Mcnatt approached him with the proposition of having the women kidnapped, sexually assaulted, and killed. Kent claims he didn't take Mcnatt seriously until Mcnatt produced information, such as their names and addresses, to give to fictitious people. Kent had made up names Samson, David, and Goliath in order to buy time to figure out what to do. Notably, he did not contact the police immediately. In Volume 3, pages 65 to 66, Kent offers a similar excuse, claiming that in September, he pretended to be in Skype contact with these individuals to buy time under the instruction of Detective McGregor. Defense attorney LaFawn presses him on how this cannot be possible, as McGregor could not have instructed him to do this in September. Kent agrees, but then claims he was told to buy time for detectives because of the Thanksgiving holiday break, contradicting his earlier claim. LaFawn does not point out this inconsistency. LaFawn leads the witness, Edwin Kent, by asking him if his actions in fabricating the Skype conversations were not a result of any instruction from Christopher McGregor and were his own doing. Kent responds, yes. This allowed Kent to avoid consequences for his blatant lies and casts doubt on LaFawn's performance and whose side he was truly on. During cross-examination, Volume 3, page 63, Edwin Kent changes his story, stating he only obtained the information because he asked Mcnatt to provide it when pressed. However, Kent allegedly already had the police involved and had handed the information over to them sometime in November, Volume 3, page 44 store. However, he refuses to admit that this was done to provide it to undercover officers to form a case, thus undermining the timeline of events. On Volume 3, page 44, Stenunner, Kent also states he showed the officers text messages. However, during direct examination by Prosecutor Knecht, she does not mention or ask about the text messages. On Volume 3, pages 78 to 79, Stenunner, under cross-examination by Lafon, Kent states that he is not sure how the officers made copies of the text messages, only that he knows they did it somehow. When asked if he still has the same phone, Kent says no. When asked where the phone is now, he responds, "I don't know." This evasiveness is not addressed or brought to attention. On Volume 3, pages 44 to 45, Kent also states that he turned in the letter and index card in person at the Pasadena Police Department, rather than surrendering them at the scene of the disturbance where he first alerted officers. This raises serious questions about why officers would allow a person to leave the scene with such critical evidence for a case involving alleged plans of kidnapping and murder. Furthermore, Kent does not specify how much time passed or the exact date when he turned the items in to Officer McGregor. In McGregor's police report, page 35, it is noted that the letter was turned over on November 11th, but there is no mention of any index card. This discrepancy further casts doubt on the chain of custody and how the index card was introduced into the investigation. Kent's testimony also appears inconsistent. When asked on Volume 3, page 49s, if, once he received the letter, he showed it to officers and then gave it to McGregor, Kent answers yes. However, this contradicts the timeline, as it would not have been possible to hand over the letter promptly on November 8th, when McGregor first spoke to him, and then formally turn it in on November 11th. On Volume 3, page 50, Kent states that after meeting with McGregor, he contacted Mcnatt and informed him about a meeting being set up with the fictitious individuals, Samson, David, and Goliath. Kent claims he relayed this information to Mcnatt and then updated McGregor about when the meeting would occur. This directly contradicts Kent's later testimony under cross-examination, Volume 3, pages 70 to 71, Snasher, when he denies ever having direct contact with the undercover officers. When pressed on how Mcnatt ended up meeting the undercover officers, Kent claims he doesn't know and insists he had no involvement after his meeting with McGregor. However, Officer Phillips testified, Volume 3, page 88, that he spoke to Kent on the phone about the letter. This indicates that Kent had Phillips' contact information and contradicts his earlier claims that he had no further involvement after turning over the letter. Phillips also only mentions the letter in his testimony, consistent with McGregor's police report, page 35s, which makes no reference to the index card. This raises further doubts about the chain of custody and the integrity of the evidence. During cross-examination on Volume 3, page 51, Kent testifies that the nature of the disturbance was a fight in his front yard between his girlfriend's brother and somebody else. He refuses to testify to who the other individual was, and defense attorney Lafon does not press him to elaborate on the identity of the individual, not even their sex, age, or relation to the family or the area. It is reasonable to believe that this individual may also have been fictitious, as the incident report or call for service could easily have been introduced to remove all doubt and provide transparency. This is highly suspicious behavior from the defense attorney, as once again he gave up an opportunity to question the integrity of Kent's story. On Volume 3, page 53, Kent continues his vague account, stating that the brother had left when police arrived, as did the unknown individual, but that the brother later returned. Mcnatt claims he was told by Kent that the disturbance was, in fact, a fight between Kent and his girlfriend's brother, possibly named James Ketchum, as Kent attempted to stop him from driving drunk and getting a third DWI. However, no records of this alleged DWI appear to exist. Furthermore, the Pasadena Police Department has delayed providing the call for service records for Kent's address during October and November, which the prosecution and witnesses cite as critical months in their timeline. On Volume 3, page 72, Kent denies ever seeing Mcnatt face-to-face after Mcnatt's first meeting with undercover officers. However, on volume 3, page 73, when asked a straightforward question about whether he just spoke to Mcnatt, Kent slips up and admits that he went to Mcnatt's house after the first meeting and that Mcnatt was upset. Once again, LaFawn does not preserve this point or call Kent out on his blatant lies. Also on volume 3, page 73, Kent lies again, claiming he never spoke to the undercover officers. This contradiction is not addressed by LaFawn or anyone else during the trial. On volume 3, page 75, during cross-examination, LaFawn asks Kent if he ever told anyone that he was previously a Navy SEAL. Kent responds, probably, which is a bizarre and non-committal answer. On volume 3, page 76, Kent later says, I don't remember, but I never told anybody I was a Navy SEAL. This casts significant doubt on Kent's credibility as a witness, as his testimonies. It is also notable that during the trial, it was never mentioned that MacGregor instructed Kent to obtain incriminating audio recordings of Mcnatt in order to further the investigation as directed by Mcnatt, according to MacGregor's police report.